Our second case this morning is a motion for discretionary review, case number 61006-0, Daniel Auderer v. City of Seattle.
Thank you. I'm ready to hear argument on the motion. It looks like 3 minutes have been reserved for rebuttal time.
Yes, thank you, Your Honor. Joel Ard for Plaintiff Dan Auderer, asking the court to return his defamation suit against the corporation he sued to the court where he properly filed it, Thurston County. My argument will address first why venue is proper under the specific venue statute and then why also under the general venue statute. But I want to begin by rebutting one overarching position that Seattle takes. It doesn't quite explicitly state this, but it's the ground on which all its arguments rest. Seattle asserts that a municipal corporation, or maybe just the state's biggest municipal corporation, gets a special venue rule. But the Supreme Court and appellate courts have rejected that claim for over 100 years in an unbroken line of cases. The City of Seattle, for venue purposes, is Acme Widget Co. It wants this court to think it's special, but it's not for venue. Like any corporation, RCW 412-0203 is the specific statute governing personal torts. It governs over any general venue statute. And the relevant tort here is defamation, so Mr. Auderer can sue in any county where all or part of the claim arose, the literal text of the statute. So the relevant question for venue is, where does all or part of the tort of defamation arise? If part of Seattle's defamation of Mr. Auderer arose in Thurston, he selected a permissible venue and it can't be moved. There's really two cases that answer this question. What does it mean for a tort to arise in part in different counties? And then where does publication or harm occur for the tort of defamation? The first question was answered in 1920 in Pratt v. Niagara. The second question was answered by the second restatement. It's answered in Keeton v. Hustler. It's answered in Theory v. Atlantic Monthly. Seattle has two objections to the rule of law. The cases are old and the statutes in question were different. Well, the statutes were different. One addressed specific venue under a different specific venue statute, and the other one answered a certified question on the state's long-arm statute. But they're accurate, they're correct, they're never overruled like Erie Railroad or Washington Shoe. In both cases, the state Supreme Court asked and answered the venue question presented here. Pratt holds that a cause of action can arise in part in multiple counties, and the statute, of course, acknowledges that when it says in any county where it arose in whole or in part. A cause of action arises in part in one county and in part in another. It can be commenced in either of them. The state Supreme Court applied that rule to defamation 57 years ago in Theory v. Atlantic Monthly. The question posed there was, where did the tort of defamation arise? It cited Keeton, it cited the second restatement. Yes, it was in the context of the long-arm statute, but the question was the same. Where does the tort arise? And the court said that defamation arises where damages are incurred. And of course, the second restatement and Keeton say that where publication occurs. The restatement is still governing law. It was reiterated in 2013 in Keeton v. Lay. Defamation consists of 4 elements, citing the second restatement: a false statement, publication, fault, and damage. So following Pratt and Theory and Keeton, all good law, defamation arises in part, and therefore venue is proper, in any county where either publication or damages occur.
I understand the argument that the cases are old, but I also understand that they talk about simple elements of a defamation claim and take them as they are. This is sort of a wider question. I mean, is essentially now defamation a statewide tort because of the online publication of everything and anyone can read anything anywhere?
No, I mean, it certainly can be,
okay.
And it can be a nationwide
this
tort.
Might be a little bit outside what we're talking about.
No.
I just had a question.
Fair question, but it can also be a nationwide tort. I mean, publication on the internet is viewed as publication in the location where it's read for purposes of the long-arm statute, for purposes of venue, I mean, for all purposes. A lot of defamation doesn't occur on the internet, even though we seem to live on our phones. But yes, to the extent it's published on the internet, it is a statewide tort.
Okay, go ahead.
So Seattle's asking the court to apply a different statute, the one that applies only to individual government officials as interpreted in Johnson v. Inslee. Again, not the first municipal corporation to ask for that, and it has been rejected. It was rejected in Hickey v. Bellingham. Seattle cites that case, but the Hickey court rejected this very specific request. Again, a case that's never been overruled. They say, well, the official acts venue statute was recently reinterpreted, but that doesn't mean that it applies to municipal corporations. A corporation like any other. Hickey also reiterated that municipal corporations are subject to the general venue statute on the same terms as any other corporation. The city does business outside its county. It's a legal resident of where it does business. The allegations of the First Amendment complaint as to doing business are drawn from PDC filings. They show that Seattle does business in Thurston County. Even under the general venue statute, it's a proper venue. And to the court below, Seattle did not contest the allegations showing its extensive business, did not present any fact arguments about the scope of that business, the nature of the business. It left that entirely untouched in its arguments to the court below. Only to this court does it start to argue for the first time, oh, it's not enough business, it's not the right kind of business. It also says that in Hickey, it seems to claim that Hickey says corporations can't do business outside their county. Hickey says exactly the opposite. And there was a fact presentation to the court on venue by the city of Bellingham, by a city attorney who said the business that was alleged to have been done outside Whatcom County occurred in Whatcom County. So in that case, the municipal corporation presented specific fact evidence unrebutted to the court that it did not do business outside Whatcom County. There's nothing like that in this case, and in fact, it's unrebuttable. The PDC filings show that Seattle does 6 figures of business day in, day out, all year long, every year in Thurston County.
So just make sure, this is the general jurisdiction statute, and you're saying that essentially because of this, and again, this is a little bit outside what we're talking about, the specifics here, Seattle can be sued in Thurston County for anything.
On the allegations of the First Amendment complaint,
Okay.
unrebutted by Seattle, yes, it is subject to the general venue statute like any other corporation who does that amount of business in Thurston County. Seattle's only response to that is, well, that can't possibly have been what the legislature intended, but it is the literal text of the statute.
We say that all the time.
Interpreted by this court that says a city is like any other corporation for purposes of venue. May not be for other statutory purposes, but for purposes of venue, it's just another Acme widget code doing 6 figures of business in Thurston County. So its venue is proper there under the general venue statute as well.
Thank you.
Thank you.
Go ahead.
Your Honor, I'm Shannon Phillips on behalf of Respondent City of Seattle. Mr. Auderer has the burden of establishing that there was an obvious error committed by the trial judge because there is no implication outside of the courtroom. He cannot get there because he is contending there was an obvious error that the trial court committed where it is based on a set of largely hypothetical and highly attenuated facts and no actual authority for these novel theories that Mr. Auderer has that would cause the trial judge to think this is the clear answer to the question. So on the first issue of where the tort was committed, Mr. Auderer cites 2 jurisdictional cases about minimum context. Now, while there often is overlap with venue, they are cases about jurisdiction. They are also cases involving media publishers. So defamation claims, and there's been a specific body of case law developed with respect to media publishers who put their publications out into the world. Mr. Auderer has not cited to any authority that extrapolates that to someone like the City of Seattle. And look what his allegations are. He says, the City of Seattle communicated with a content creator at the Seattle Times. We don't know precisely what that communication was, how that leads to something the Seattle Times.
Well, I mean, that would happen all the time. If the Seattle Times is looking to verify a fact in an article they're publishing, they would presumably communicate with the subject of the article.
Sure, but when you were saying they are not suing the
No, I'm just
Seattle
saying
Times.
it's a matter of routine journalism.
Right.
Go ahead.
Yes, I'm saying, but where you are asserting a defamation claim against the City of Seattle, the
Right.
act by the City of Seattle is that it communicated something that is not alleged to the Seattle Times. There's no allegation that communication happened outside of Seattle or anywhere near Thurston County. Something was published by the Seattle Times.
Right.
And they're making the supposition then that, well, that theoretically could have been heard in Thurston County. And calls were received by Mr. Auderer. We don't know where those people called from. We don't know where they got whatever content caused them to call. He also alleges that this was discovered in conjunction with a Public Records Act request, so it's possible they got it through that. So to connect the city of Seattle and say, the city of Seattle's actions occurred in part in Thurston County, where what is alleged is that the city of Seattle communicated something to the Seattle Times, or that the city of Seattle published Mr. Auderer's own words on its website, the police blotter in Seattle. So how that leads to, and again, he hasn't said that his specific words are what are the defamation.
Well, I don't think he's saying that everything happened in Thurston County.
Right.
I could be wrong. I think he's saying that the last element happened.
Sure.
in
Well, he
Thurston
also
County.
says the publication. So this addresses the publication. And so we would say nothing there happened in Thurston County by the city of Seattle. So then the damages. So he says, I received phone calls at my home in Thurston County. We think it is not obvious error for the court have looked to Johnson v. Inslee. And again, the city of Seattle has never said that the city is a public officer. It's that the court was interpreting similar language of,
Okay.
yes. And so based on that, it is not an obvious error for the court to say there is nothing special about Mr. Auderer being in Thurston County in this situation, because the acts that are being challenged occurred in a different county. And we would say the same is here. Again, what he is saying is he was told he shouldn't come to work because of calls. He, at some point after that, received calls from someone, from somewhere. We don't know what connection they have to anyone. We don't know where they got their information. He received those at his home. That is no different than any other tort where damage is a required element. And we don't see clear authority saying, oh, a tort occurs in part anywhere that someone feels something. You look at, for example,
Well, I mean, that's where I was sort of getting with in the modern era. Anyone in any county can pull up a Seattle Times article. And just this expansive idea of where the damages element can occur essentially mean that defamation is now, can be tried in any county.
we aren't seeing that certainly on behalf of non-media publishers. And again, some trial court may adopt that theory at some point, and it may rise up through the Court of Appeals and the Superior, and then it becomes the law of the land, and then it would be an obvious error.
And but you're saying it's not.
We're talking about an extremely novel theory that the judge said, this is not, I do not see this supported by the authority. The next part about what the residence of a city is. Again, this is a very novel theory. It is not supported by the cases. In the Hickey case, the court said that it wasn't because no one made the argument that the city of Bellingham had business contacts with its adjacent county. And when Mr. Auderer's counsel says that it was admitted it didn't do business, on page 26 of our brief, in our footnote, we say exactly what was in the declaration, that all parties in this case are residents of Whatcom County. That's what the city attorney said. Now, Mr. Auderer might like to infer, well, maybe they had this theory that we do business and that exists and we don't do business, so that's what we mean. That's not the statement. They said the city of Bellingham is a resident of Whatcom County. And if you again look in the Roy cases versus city of Everett, the court said if the firefighters and the city of Everett were the only defendants, they could have the case in Snohomish County because they are residents there. So again, novel theory that because the city of Seattle does what, and again, Mr. Auderer says the standard is it has to be more than incidental, approximately $100,000 of lobbying in Olympia for an entity as large as the city of Seattle, that means the city should be treated as a corporation defendant. Again, where is the case that says a municipal corporation is treated as a corporation defendant for purpose of the venue statute? Mr. Auderer hasn't cited it. I'm not aware of it. And
well, I mean, you're doing exactly what he argued against, which is specifying this down to a municipal corporation. And what he's saying, I think, at least for the residents thing, is that any other corporation with similar types of contacts with Thurston County would be seen to reside there for the purposes of venue. And he can correct me if I'm wrong.
Sure.
trying to summarize his argument, but that's what I was getting from him.
So, yes, what I see is, again, looking at the Hickey case, the Roy case, that cities are being treated like persons that have a residence, and the residence is where they are located. We do not see cases where courts are treating a municipal corporation for purposes of this venue statute as a corporation defendant who transacts business in various places. So again, some court may someday adopt this theory, and we may see that because of how business goes all over the state, that any city can be sued in any county. But what you get from the Hickey and the Roy cases are, no one was making that argument there. The court was saying the residence of the city of Bellingham is in Whatcom County. The residence of the city of Everett is in Snohomish County. No one said, but those Everett transit buses roll down I-5. Again, maybe Mr. Auderer's counsel is much more creative than all the other lawyers addressing venue, but that answers the question of, it is not an obvious error for the trial court judge to not have adopted a highly novel theory of venue that has not been established in any of the authority offered by Mr. Auderer. Unless there are further questions? I'm done.
No, thank you.
Okay, thank you.
Thank you, Your Honor. Nothing's novel about this at all. Hickey says exactly what counsel claims no case says. A municipal corporation is a corporation like any other for purposes of venue. The literal words of that case. You want to find a case that says Seattle is just Acme Widget Co. for purposes of venue, Hickey says exactly that. The cases do not treat municipal corporations as persons. Bellingham asked for that in Hickey, and the Hickey court says, you're not a person, you're a corporation. It says that that claim, the claim that is supposedly so novel it shouldn't be reviewed by this court, was presented by Bellingham and rejected by the court in Hickey. They said that would be a really odd way for the legislature to write this statute. Is this an obvious error? Absolutely. Publication occurs where a defamatory statement is heard or read. That's the restatement second. It's the law of the state of Washington. It's been the law of the state of Washington for decades. Theory says that the tort of defamation occurs where the harm is felt, and that the harm is felt where the defamed person resides. Keeton v. Hustler says that. That's the Supreme Court applying the restatement second, which is the law of defamation in Washington. That's an ancient case. It is obvious error to reject theory from the state Supreme Court, reject Hickey, reject Keeton, reject the second restatement. Every bit of governing law on the tort of defamation says that it occurs where publication happens. Publication occurs where the defamatory statement is heard or read. Seattle, paragraphs 43 to 45 of the Second Amended Complaint specifically allege that the city of Seattle defamed Mr. Auderer by violating the SPOG contract, violating the municipal code, posting a video that defamed him through lack of context. I'm not saying the statements are false, but making statements with lack of context is defamatory, and that's what we're alleging. But we have alleged that Seattle directly defamed him. They also defamed him through their cat's paw, Mike Carter, that they directed that defamatory publication in the Seattle Times and on the internet, that those defamatory publications made directly by the city of Seattle on their internet site that are still available on the internet site, that the defamatory communications through Seattle Times are read and heard in Thurston County. That's Keeton v. Hustler. That's second restatement. That's where the tort occurred. And the harm occurred there. That's theory. Theory says that defamation occurs where the harm is felt. And as to their treatment as a corporation, Hickey says municipal corporations are not persons. Municipal corporations are corporations like any other. So that case law goes back for decades, and it's obvious error for the court below to ignore every bit of it. Thank you.
Thank you very much. I'd like to thank both of you for your arguments today. And I am going to take this matter under consideration and issue a written ruling. Could one of you update me? This has been officially transferred to King County. Are King County proceedings moving forward? What is the status of this case?
So there was an order transferring, and
Okay.
then we started this appeal process.
Right.
I can say, while I would think in this age of the internet and Court of Appeals things move quickly, what we were initially told is that it can take a while to transition these. So it has not been assigned to a judge in King County. And I
Okay.
don't know if that's pending this review or
Yeah,
it is in the universe.
You know, everyone
That's what I
moves at
know.
their own speed, I guess. I don't know if
I
you
mean, I
have
guess
anything
I'm
else to
under the
add.
impression that the Thurston County clerk hasn't done anything in this court because,
Okay,
I mean, I think if the King County clerk got it, they'd assign a judge to it. We don't have a King County caption.
okay, all right. Well, I will assume it's in some state of limbo. If either
Maybe
of
less
you,
pressing than the issue.
what was that?
It's maybe less pressing than.
Oh, I'm not, part of my role is handling child issues, but part of my role is also making sure that I don't impede Superior Court proceedings as much as possible. That's the reason I'm asking. If either of you get some notification, either from Thurston County or King County, about this case being set or moving forward or have important dates that you want to let me know about if it's still pending here, I really would appreciate it. It does help me get my work done in a timely manner, in a way, hopefully, that is as convenient as possible for the parties and the Superior Court systems. With that, unless either of you have additional questions, our morning argument will be adjourned.
All rise.